Is liberty dying where you live? Escape to Keene at freekeene.com.
Please be seated.
This is case 2013-0885, City of Keene versus James Cleveland et al. Mr. Bauer?
Thank you. Your Honor, I request 2 minutes in reserve. Clerk has noted I'll take 11 minutes. My brother, Steve Buckley, will be happy. Deacus will take 2, and I'll reserve 2 if needed. Thank you. May it please the Court, my name is Charles Bauer from Gallagher, Tallahassee, Gartrell, and Concord. I represent the City of Keene in this case. The 3 parking employees who are members of the City of Keene, Jane, Alan, and Linda, have all suffered work-related stress and anxiety due to the constant, proximate haranguing by the 6 defendants in this case, as alleged in the complaint.
They brought their own suits?
Pardon me?
Have they brought their own
No, they have not.
suits?
Can I ask you
That's an issue then, is the city's standing to bring a lawsuit based on their alleged suffering.
I understand, and if I may address that issue?
No, please.
That issue, the complaint, the petition that was filed before one of the employees quit his job because of the stress directly related to the conduct, the targeted conduct of the defendants. The petition to enjoin was brought in the first instance in order to prevent the workplace harassment and to protect the economic interest of the city in its employment relationship. Once we were going into this case, unfortunately, the lower court did not issue the injunction, and one of the individuals quit his job directly related to the conduct. Secondly, another employee, Jane, cut back her hours because of the defendant's conduct. And the third employee, Linda, has indicated that she's been considering filing a stress-related workers' compensation or disability claim. So there is standing by the city to protect its economic interests in the employment relationship, as well as protect its employees in the workplace environment.
Well, its economic interest in the employment relation, I mean, I assume it does not have much of an interest in paying salaries. It may have an interest in the services that they perform, but what's its interest in paying salaries? I mean, if you look just narrowly at that seems to me to be more of a detriment. I mean, they're having to pay something out. If the claim is that the services themselves that they're providing are beneficial and that the city is being harmed in that regard, I can understand that claim.
No, Your Honor, with all due respect, no. It is not limited to the salaries. What it deals with is when there's an employment relationship, there's an investment of time, money, effort, services, but also the possibility and the potential, in this case, of people quitting their jobs because of unfettered conduct,
Well,
because of disability
we have
claims.
to even get to those issues, because if we agree with you that there needs to be some injunctive relief, then that should solve your problem. And I noticed that the area of protection that you're looking for apparently has shrunk over time, because your brief says what you really want is a reasonable safety zone, and in your view, that would be 15 feet or 2 parking meters. So if that's where we are today, if we just assume that we agree with you that some injunctive relief is appropriate, if we agree with you that the 15 feet, 2 parking meters is warranted in this case, doesn't that obviate all of your other claims? It should solve your problems, no?
It solves the most immediate and pressing problem on the streets, but it does not solve the problem of one employee quitting because of the unfettered conduct of defendants, that there was a breach, there was an intentional or negligent interference with contractual relations conspiracy, and there was a negligence claim, all of which I believe should have gone to a jury for factual determinations.
Can I just ask you, if we accept this, your theory here, does that mean that the police officers in Ferguson, Missouri, have a lawsuit against, and I'm not talking about the protesters who were throwing things through windows or anything like that, but just the people who were protesting because they were angry about what happened, presumably getting in the face of many of the police officers. Do they have a lawsuit against the protesters?
I'm glad you asked me that question, because it's a very relevant question, not only for the nation, but this case as well. I believe that if there's a track record of a constant in your face, the proximity is the key to this case, and it could be or would be in the Ferguson matter, the proximity and the duration. If it's an incidental in your face, if it's a fleeting moment.
Well, this is going to, but if I understand it, Ferguson, it's gone on for quite a while now. I mean, would they have a lawsuit today or next month, if it kept going on?
Would the police department or the city be able to obtain an injunction based on track record? And that's important in this case, based on track record, not in the first instance. We all know that oftentimes when there's a significant public safety, there are lines drawn. There is time, place, and matter implemented. And that's really what I'm asking this court to address.
And let me follow up on that.
Yes, sir.
Time, place, and manner restriction. Normally, most Supreme Court cases involving that relate to time, manner, place restrictions that have been enacted by the community or by ordinance. Here, as I understand it, that hasn't happened, and you're in essence asking the court to enact such an ordinance. We're not looking at the constitutionality of the ordinance. You're asking us as a court to create such an ordinance. That troubles me.
Well, I'm sorry that it troubles you. It shouldn't, Judge, because most recently, the United States Supreme Court, in the case of McClellan, said that this is the 35-foot buffer zone around the abortion clinic that was by ordinance, by legislative enactment, said it was too broad. What it said was, and it's quoted in my brief, that a court can tailor the specific injunctive relief to the specific individuals.
Sure, but
for the specific conduct.
The court eliminated the buffer zone.
Yes, it
Basically said there isn't going to be one.
It was too broad because they said they had less restrictive alternatives, and the less restrictive alternatives was injunctive relief. It comes, if I may, right out of the McClellan case.
I've read it.
Okay.
And let me just ask you this about the injunctive relief.
Sure.
It's not clear to me. It appeared that the trial court understood the injunctive relief to be a remedy for the tort claim, the tort claims that were asserted. And my question is the request for injunctive relief a standalone claim, or is it a function of relief because of the tort claims that you're asserting?
It can be both, Your Honor. It can be an injunctive action to prevent harm from occurring, so long as that harm is probable or likely to occur. But in this case, it went too far. Because the injunction was not issued, then there is a legal claim with regard to interference with contractual relations, negligence, and a conspiracy theory.
As I had it, you say that your client is not trying to suppress the viewpoints expressed,
Correct.
but only the means.
Correct.
So I take it that you would have the same position if, for example, take a different example, individuals were following these parking officers and continually screaming lullabies.
Oh.
So that they weren't expressing any particular viewpoint, but they were following, as you say, in very close proximity for an extended period of time. So you say it is that conduct. So you would be in here if there were people following your officers, screaming lullabies in their ear all day and waiting for them outside the bathroom to resume screaming the lullabies in their ears. I mean, you would be in here asking for the very same relief, I take it.
You are absolutely correct.
What if the police were, what if a group of citizens decided they wanted to follow the police around with cameras? They decide that they're going to just put cameras, you know, and follow the police around. Can we get an injunction against that?
Depends. There's an absolute right. The First Circuit Court of Appeals has said twice now in Glick and in Garrick that there is a right to videotape not only police officers but municipal employees while they perform their jobs. However, it has to be done from a safe remove. And the safe remove is what I'm asking this court to allow.
Can I just ask
that's what the trial judge got wrong.
Does the behavior here violate any municipal ordinance or any state law in your view?
It could, Your Honor. I mean, there could be some...
Are you asserting that?
It could or it does.
Well, the bumping into, the touching is assaultive behavior. Now, is it one of the questions I anticipated, well, why don't you just arrest them?
I was going to ask that. Go
I
ahead.
anticipated. The reason you don't arrest people is because we're not there to try to stamp out the content, the goal, the message. Arresting does that. What we're asking for is to please step back out of the face. Give us some breathing space. So, arresting is not the way to go because that's too onerous. That shuts down the content.
Thank you.
Now,
Your time is up.
yes, I see.
Mr. Buckley?
Thank you very much.
May it please the court, Stephen Buckley on behalf of the New Hampshire Municipal Association, our organization represents 232 of the 234 cities and towns of the state of New Hampshire. Public employment is not a license for use by citizens. Public employment is not a license to employ invective or to invade the personal space of public employees. The trial court, from our perspective, did not adequately undertake a balancing of the First Amendment rights that are asserted by the defendants here and the public interests that the city has in protecting its employees from abuse.
Do you agree with Attorney Bauer that 15 feet or 2 parking meters, this floating zone of protection, would be adequate?
I have to confess we did not participate in the case in the trial court, and I'm not prepared to say
Wouldn't that be a judgment for the trial court to make anyway?
That's what I would suggest, and I think that's the problem with the trial court's decision. The court did not get to the point of balancing these interests, so I would have to defer to the city officials as to their decision-making and how they operate their the parking enforcement.
So what you would say is that if we were to agree with your side of the case, a remand for that purpose would be in order?
Precisely, and I think that what we would argue is that the situation we find ourselves in is very similar to one that was found in the Chaplinsky versus New Hampshire case. In Chaplinsky, the party was brought to court for saying such things as goddamn racketeer and damn fascist. Well, in this case, the parking enforcement officers are being chased around, they're being disparaged, demeaning things are being told to them. There was one occasion when...
Well, you know, but can I just ask you, let's put aside the perimeter thing, whether it's 15 feet or something like that. Are you saying that in addition to that, the injunction should be able to say, you know, the protesters or the people that are doing this shouldn't be able to say sort of nasty things to the parking meter people? You know, you're a bad person, you're, you know, whatever. You think of the appropriate invective, but that they shouldn't be able to do that?
No, I think my point is that in the balancing assessment the courts are going to take into account the things that are being said and balance that against the means and methods that are employed by the defendants to convey their messages, and then craft relief which provides the buffer. All we're seeking is a buffer. We're not trying to control the content of the message.
Thank you.
Thank you.
Mr. Meyer?
Thank you. Madam Chief Justice, may it please the court, my name is Jon Meyer. I represent 5 of the 6.
Mr. Meyer, if I did this to you, you would be alarmed and offended.
She's around.
If I did this to you, you would be alarmed and offended, correct?
In what?
What is alleged to have happened in this case? Have you read the facts?
Your Honor, I was sat through 3 days of hearings.
All right.
And
Why is my question out of bounds?
why is your question out of bounds? I guess I would respond, Your Honor, by, well, two things. Well, many different responses. First of all, the actions of defendants are grossly overstated. I mean, 95% of the testimony in 3 days of hearing was how respectful defendants were, and how we were asked to give more space, they gave more space, and virtually every complaint. I mean, what the trial judge did is he said after 3 days of hearing, involving essentially several years and thousands of interactions, this is the worst testimony presented. But overwhelmingly, the testimony was that the defendants, the demonstrators were respectful, that they engaged in interesting
What about the occasions?
But
What
they're
about
not-
the occasions when they weren't?
Right, and that's what I want to address. And it goes to the point in the court said in the Hood case and Garrett, which is it can be difficult being a public servant. That it can be, permitting private citizens to follow around a police officer with a video camera, where their work is stressful enough. When you add this, yes, it can be very.
But I understand that they're not objecting to the video camera,
Well-
the picture taking.
They are. Well,
They said, they told us, they're objecting to the proximity of the activity. They're not objecting to what was said, they're not objecting to the videoing. They're objecting to the very close, continual, on occasion, proximity.
Your Honor, that's not why. Look, this is on a motion to dismiss, and we're judging the allegations in the complaint. And that's not what the
The
complaint
inferences are supposed to go the other way,
Well,
though, as you know.
the extraordinary thing that's happened in this case, in this appeal, is basically the plaintiff has dropped their case. In other words, they claim interference with contractual.
Shouldn't that make you happy? I mean, shouldn't you say, great? I mean, we're trying to,
Well-
they're pulling back.
Well-
You won a couple of issues, right?
Well, I want more than a couple of issues. They basically conceded. The trial judge's opinion said the interference with contractual relations tort does not fly against peaceful demonstrators on the public way. And that really is not seriously disputed. Then they threw a claim of negligence, even though there's no negligence alleged.
Do you
They brought that.
say,
So,
do you say that your clients would be able to follow an individual within 12 inches for an extended period of time, waiting for them outside a bathroom and screaming lullabies? Do you say that that should be permitted? Put aside what they're talking about, just the proximity and conduct, which isn't conveying a political message. Can somebody do that?
Your Honor, no. And there are statutes and ordinances that prohibit it. The problem in this case is not that. It has nothing to do with proximity. The issue of relief is not even properly before this court. I mean, there is no legal basis to this case. And what the defendants are essentially saying is forget the fact there's no legal basis, just act as supported equity. Go out there.
The court
and do the right
denied
thing.
the petition for injunction.
Pardon?
What do you mean there's no legal
There has to
basis?
be there has to be probability of success on the merits. For the court to simply issue an injunction where there's been no legal violation, when you're dealing with the protection of constitutional rights.
Well, isn't that what Madsen was? I mean, in Madsen, there wasn't a statute that was violated, but the court upheld a buffer.
Because Madison had a history of extremely serious acts of violence and violations of the law. I mean, the factual history behind that is entirely different. Essentially, defendants are acting in this court to sit as a city council and set up an
There's no
ordinance.
danger of that, Mr. Meyer.
Hopefully, but that's essentially the rule.
Can I just ask you, Mr. Meyer, suppose that we said, look, and I don't know, 15 feet may be too far, but suppose we said, look, the plaintiffs here are entitled to an injunction that they have to stay back 5 feet or 10 feet. That's the only restriction. They can say everything that they were saying before. They can follow them to the bathroom, but they just got to stay 10 feet away. They can tell them that they're terrible people for enforcing this parking ordinance, that they should quit. They can do all of that stuff. They can follow them 24/7 if they want. They just have to take, the only restriction is they have to stay back 10 feet. What's wrong with that?
Your Honor, peace of mind of public of PEOs, parking enforcement officers, is not a compelling interest. It does not justify restrictions on First Amendment rights. And the Supreme
So
Court...
they can get in their face and they over and over again.
So let's spin that right to where you're standing right now. This is really important. Answer my question.
Well, Your Honor, I'm not, the issue of this case is whether or not tort liability can be imposed on the
So you
defendant.
can't answer my question.
But, Your Honor, my point is that that question is not presented by this case. The question that's presented by this case is whether or not you can impose tort liability, in particular, the interference with contractual rights.
You may
on the defendant.
very well be right about that.
But that's what
And if you are, where does that leave the case?
the trial judge said you can't impose tort liability on this conduct.
There are
Therefore, he
two
dismissed the complaint.
cases, the claims for tort liability and the petition for injunction. Two cases.
Your Honor,
You're claiming that claims, right?
Your Honor, no, the petition for injunctive relief is not separate from the tort liability. The petition papers are based upon an alleged tort claim. There was no separate equitable filing.
Well, that's the question I asked Mr. Bauer. He gave a very different answer.
Right, and a different answer, I believe, and when that same question was asked by the trial judge, the answer was much more equivocal. But the fact is that in terms of the pleading, putting aside what counsel said during oral argument, looking at the pleadings of this case, and that's what the trial judge was basically ruling upon. He was ruling upon the pleadings before him, which I think is his appropriate role. And those pleadings do not request injunctive relief absent some sort of tort violation. But again, Your Honor, I would submit that if they did, that would be...
Their petition for injunction said, we only want an injunction if you find there's tort liability? I don't get that.
Well, the petition for injunctive relief says that we are going to make a probability, we have a probability of success on the merits. And success on the merits in that petition is defined as interference in contractual relations. That is what they say in their papers, and it's in the appendix.
So you would say that the trial judge was absolutely correct looking at the face of the complaint and measuring it against theories of law.
Exactly.
And they could bring a Madsen case. I mean, they could bring a case that's a standalone, just we're not getting enough room and we need 20 feet. That would be a Madsen. And they could bring
So you're saying
conceding that.
if they brought a complaint as described by Justice Bassett, you'd have another 3-day evidentiary hearing.
Your Honor, even in Madison, it has to be a predicate for a violation of the law. I mean, you can't just grant injunctive relief. I mean, I have never been able to find any case, particularly a case involving constitutional rights, where there was no violation of the law. I mean, you can't just sort of say, well, this is the right thing to do. I mean, that's the role of the city council. That's the role of the legislature. That's not the role of the court. And I would submit that it's essentially lawless to act as court of equity without any legal basis. I mean, that's the definition of lawless.
Let me give you a hypothetical. If you had an individual who was on the other side of the case from you, who started following your clients as they left your law office, doing what is alleged in this case,
Right.
do you say, gee, sorry, nothing I can do about it? My guess is you'd be in court pretty darn fast with an injunction petition.
Your Honor, if I thought behavior was improper, as is pledged here, I would be in front of the city council. And the city of Keene certainly has the power to go to the city council. Surely we go to
You would
court.
go to the city council before going to court to protect your clients who are being followed and treated in this way?
Your Honor, yes, I would, absolutely. But the difference is, Your Honor, the difference is, I mean, I'm not sure if you're talking about an ongoing case. I mean, you're talking about contempt in an ongoing case. That's special circumstances. But if I represent some clients whose rights I thought were being interfered with in the public streets, I mean, the first place I would go would be the authority to govern the public streets, which is the city. And I would go to the council, and I would go to court ordinance, or I would go to the state. And there's state laws, there's all that. And I mean, if I thought that my clients' legal rights were being violated, and there are a variety of criminal statutes that govern behavior in public streets, then I would seek a prosecution.
So, as I understand it, there's an allegation that at least on one occasion there was physical contact. Would that be a violation such that an injunction could issue?
Your Honor, just to flesh out the facts of that, what happened was that my clients put flyers on windshields, and the parking enforcement officer reached for the flyer, my client reached for the flyer at the same time, and ended up impacting this woman's wrist. I cross-examined her about it, and she said she understood it was an accident. So I don't think that was factually would be considered an assault. But if in fact he engaged in assault, yes, the appropriate remedy is for a criminal prosecution, in which case my clients have the right of criminal process, of due process. One case that I just want to make reference to is the Claiborne hardware case, although admittedly that's primarily issues with damages. And again, that was a civil rights demonstration. The state, the white merchants who were being boycotted said our business is being decimated. And there was lots of acts of violence and all sorts of difficult things that occurred. And the Supreme Court said you can't do that. You can't show demonstrators that way. You can't be indiscriminate as poor liability is.
Can I ask you, Mr. Meyer, is part of the relief here, I mean, I guess this wasn't clear to me, is part of the relief that's being sought here to prevent your clients from sort of feeding the meters?
No.
That's not.
And one item of relief that is being sought, which has been ignored, is there was specifically, they amended the complaint to add a civil conspiracy claim. The purpose of the civil conspiracy claim is to make each client liable for the damages incurred by every other client. This is a case of damages, seeking financial remedies, draconian financial remedies against my client. And that's what this case is all about. Now, if they want, again, if it was just a matter of injunctive relief, I don't believe that the Superior Court is the proper place to go for that. And beyond that, there are many important...
Where else would one go?
I'm sorry, the council, first of all, the first place to go, yes, the Superior Court is the right place to go, but not for injunctive relief out of the air. It's to enforce the ordinances and the laws that already exist. And if you feel the ordinances and laws that already exist are not adequate, then you go to the council, you go to the state legislature. Now, so it's just a particular case in the briefs.
Let me ask you, I'm sorry, your time's about to run out. I want to get your view on something. Madison, which I keep coming back to, seems to be the most analogous case because there's not a particular ordinance at issue. And in that case, in his concurrence, Justice Souter said that the protesters had acknowledged that the city had an interest in public safety and in order, and that therefore there was a governmental interest in flagging. Do you concede that here?
No, Your Honor, I don't. And I would say that Madison is the exceptional case. I believe it's the only case where I know where injunctive relief is not held without some sort of ordinance or state law being violated. But the reason for that, again, is that Madison came against a horrendous background of violence and clear violations of state laws. I mean, that wasn't even in dispute. The question was the issue of remedy. And that's certainly not the case here. But my point is that there are adequate laws and ordinances already in place to address any alleged abuses. And the other point is that Part 1 Article 8 of the New Hampshire Constitution, which is relatively unique to the state, gives individuals the right to hold government accountable. And there's no question that that can be difficult and painful for public employees. And one of the prices of public service, Justice Hicks, I believe, you have to put up a certain amount of grief.
I agree with that.
But we as private citizens don't have to put up. So going back to your question, sort of the argument, I think that I as a private citizen, in a sense, have more rights. But even then, my rights are rights of tort, rights of criminal law, not rights just to go seek an injunction without alleging a violation of the law. But I think particularly in this state where there is a right of accountability, that's essentially what my clients and their video cameras are doing. Now, in terms of...
Let me give you another example. Let's say you find yourself in a position where someone is following you within 12 inches, as I understand is alleged here, saying nothing, but walking behind you, 12 inches behind you, everywhere you went. Everywhere. And would wait outside when you went to the men's room, saying nothing. So you would argue, well, what law is being broken? So, too bad, go to your local council and try to get them to pass a law that following someone within 12 inches is illegal in some way.
Correct.
What is the remedy in that case? case. I mean,
Well,
I'm
remedies-
trying to imagine how I would feel if someone followed me every day, all day.
If there is an ordinance that's being violated, then there's no question about the appropriateness of the relief. And there's also the availability.
Let's talk, no ordinance, no assault,
I
no
know,
physical
but
contact.
that's what I'm saying.
There's no relief in that
Well,
case?
John, in that case, I think the remedy is to go to the city council and get an ordinance passed that over some sort of, and again, for the city, you need to go to an ordinance. I mean, their council passes ordinances every week. It's not
So
like-
what would this ordinance say?
Say-
If I had someone
You can't
following me every step that I took on a public street, what ordinance
But you don't have
would be following?
the nation of laws is to have general standards, not to do things on an ad hoc basis.
Precisely.
But-
So I can't go in and say, can you pass an ordinance that won't let somebody follow me 12 inches away?
But otherwise, well, I mean, typically, there is a stalking remedy, domestic violence remedy, I mean, there are a host of remedies in virtually every circumstance. But if there is no remedy, if there's no law that prescribes conduct, I don't think it's appropriate to go to court and say, well, no law has been broken, none of my legal rights have been violated, nevertheless, I'm entitled to injunctive relief. That seems to me to place the court in a role that it shouldn't be placed in.
Thank you.
Thank you.
Do you need to reserve time, Mr. Powell?
Wait.
All right, then, we'll consider this case submitted, and counsel may come forward.
We'd like to invite you to visit freekeene.com. Freekeene.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeene.com also has comments and discussion forums so you can be heard. Freekeene.com.
I should be in Keene, New Hampshire with the Free Staters.